Step out of the vehicle, now.
I'm sorry, what's the problem, officer?
The problem is you're sitting in a $200,000 car and you don't look like you belong in it. Step out. I'm searching this vehicle.
Search my vehicle on what grounds exactly?
Don't get smart with me.
I'm asking a question the Constitution requires you to answer. I think
At exactly 7:14 in the evening on a Tuesday in September, on the corner of Glenbrook Avenue and Harmon Drive in Riverside, California, a routine traffic stop that should have lasted 3 minutes became the most consequential 11 minutes of one officer's career. The body camera footage from that night would later be obtained through a public records request and uploaded to the internet, where it reached 42 million views in 72 hours. Journalists covered it, law professors taught it, civil rights attorneys broke it down frame by frame, and police departments across the country quietly used it as a training example of exactly what not to do. But before any of that happened, there was just a man sitting in a beautiful car on a quiet street, being told by a police officer that he didn't look like he belonged there. And that man knew something Officer Kowalski had not yet figured out. That man knew everything. His name was Marcus Thompson, 41 years old, born and raised in Atlanta, Georgia, the son of a high school history teacher and a registered nurse. He had been a serious, focused, almost relentlessly disciplined student from the time he was in elementary school. While other kids his age were playing, Marcus was reading. Not because anyone forced him to, but because he understood early that the world rewarded knowledge, and that for a black man in America, knowledge wasn't just power, it was protection. He graduated at the top of his class from Howard University, summa cum laude, with a degree in political science and pre-law. He went on to Harvard Law School, where he served as editor-in-chief of the Harvard Law Review. After graduation, he joined the United States Department of Justice as a federal prosecutor. Over 11 years, he built cases against organized crime, public corruption, and law enforcement misconduct. He personally prosecuted and won convictions against 9 police officers across 4 states for civil rights violations. He knew the Fourth Amendment the way most people know their own home address. He knew Terry versus Ohio. He knew Florida versus Bostick. He knew Mapp versus Ohio. He knew Section 1983 of the United States Code. He had cited these cases in front of federal judges. He had explained them to juries. He had used them to put officers in handcuffs. And on the evening of September 12th, while sitting in his own legally purchased vehicle on a public road, he was about to use them again. 3 years before this traffic stop, Marcus had been recruited to serve as Deputy Commissioner of the Los Angeles County Sheriff's Department's Office of Inspector General, a watchdog role designed specifically to hold law enforcement accountable from the inside. He was feared by bad actors in uniform and respected by those who weren't. 6 days before this traffic stop, the city of Riverside, California made history. In a unanimous city council vote, Marcus D. Thompson was confirmed as Riverside's new chief of police, the first black chief in the department's 94-year history. He hadn't even completed his first full official week. He was driving home from a quiet dinner with his wife Diana, celebrating the appointment, when the blue and red lights appeared in his rearview mirror. Marcus saw the lights and felt something that wasn't panic. It was awareness. The practiced, sharpened awareness of a man who had spent 2 decades studying exactly how power gets abused. He pulled over smoothly. He told Diana to stay quiet and let him handle it. He put the car in park, turned on the interior dome lights so the officer could see inside, placed both hands visibly on the steering wheel, and he waited. He had done nothing wrong. He wasn't speeding. He hadn't run a light. He hadn't made an illegal turn. He was simply a black man driving an expensive car through a neighborhood in the city where he now served as the top law enforcement official. That was apparently enough. Officer Brad Kowalski had been with the Riverside Police Department for 17 years. He worked the Glenbrook district. He had accumulated 3 use-of-force complaints during his career, 2 of which had been quietly settled by the city without any formal finding against him. He considered himself a cop who ran his beat his own way. As his body camera footage showed at timestamp 7:14 and 32 seconds, Kowalski approached the driver's side window of the Lamborghini, and you can see the exact moment he processed what he was looking at. A black man, an expensive car. You can watch the calculation happen in real time. He asked for license and registration, which Marcus provided immediately and without comment. Both documents were perfectly in order. The car came back clean in the system. No warrants, no flags, nothing. At that point, under the law, the stop was functionally over. There was no basis to continue it. Kowalski continued anyway. When Marcus calmly asked for the specific reason for the stop, Kowalski deflected and asked where he was coming from. Marcus told him he wasn't required to answer that, but that he would appreciate knowing what traffic violation had been observed. Kowalski didn't answer the question. Instead, he changed course and said he wanted Marcus to step out of the vehicle because there had been incidents involving stolen cars in the area. This is one of the oldest pretextual justifications in the book. It sounds official. It sounds like reasonable suspicion. Legally, it is neither. A general reference to unrelated criminal activity in a geographic area does not create specific articulable suspicion about a particular individual in a particular vehicle. Marcus knew this. He had argued this exact point in federal court. He told the officer calmly and without any hostility that the vehicle was registered to him, that Kowalski had already confirmed that, and that a generalized reference to incidents in the area did not meet the Terry standard and did not give him lawful grounds to order him out of the vehicle. Kowalski stood at the window and stared for 4 seconds. Then he said he wasn't going to argue case law on the street. Marcus said he wasn't asking him to argue. He was informing him of the law, which as a sworn officer, he was required to know. Kowalski stepped away from the car. He called for backup on his radio, describing the situation as a possible uncooperative stop. Let that word sit for a moment. Uncooperative. Marcus had provided his license, his registration, asked a legal question, and accurately cited constitutional law. That was described as uncooperative. A second unit arrived within 2 minutes, and Officer Jenny Reyes stepped out and positioned herself near the passenger side of the vehicle. Kowalski came back to Marcus's window and told him he was going to conduct a search of the vehicle for his safety and the safety of the public. Marcus asked if he had a warrant. Kowalski began to say he didn't need one and Marcus cut in with quiet precision. If what, he said. If I consent? I do not consent. I explicitly and clearly do not consent to any search of this vehicle. If you are claiming officer safety, that requires specific articulable facts indicating danger, not a general statement. If you are claiming probable cause, please state what it is. If you cannot articulate either, this search would be unconstitutional under the Fourth Amendment, and any evidence obtained would be inadmissible under the exclusionary rule established in Mapp v. Ohio. There was complete silence. Officer Reyes, visible on the body camera footage, went very still. Something about the way this man was speaking had set off a signal she couldn't yet identify. She would understand it later. Kowalski made the decision that ended his career. Whether it came from ego, from bias, from 17 years of operating in a system that had never seriously held him to account, he chose to move forward with the search. He told Marcus this was his last warning and that he believed there might be contraband in the vehicle. Contraband. A new justification conjured on the spot with nothing behind it. Marcus opened the door and stepped out. He did it slowly, deliberately, with his hands visible, and before his feet touched the ground he said, clearly, for the recording, that he was exiting the vehicle under protest and under duress, that he was not consenting to any search, that he was preserving his Fourth Amendment rights in full, that he had recorded the entire interaction on his personal device, and that the officer's own body camera was capturing everything. Then he stood beside his car, hands visible, expression calm, and he waited. Kowalski searched the vehicle for 11 minutes. The center console, the glove box, the rear cargo area, beneath the seats. He found nothing, because there was nothing to find. When he finished, he walked back to where Marcus was standing and told him he was free to go. Marcus said he appreciated that and asked for the officer's badge number. Kowalski hesitated for a moment, then provided it. He had no idea that Marcus already knew the personnel file of every sworn officer in the Riverside Police Department. He had no idea he was looking at his own boss. Marcus thanked him politely, wished him a good evening, got back in the Lamborghini, and drove away. Before he had gone 2 miles, he had already begun composing the complaint in his head. Marcus got home at 8:45. He sat at his kitchen table, he opened his laptop, and he did something that would take most people weeks and a lawyer to produce. He wrote the formal complaint himself that same night, and he finished it. Before midnight, it wasn't a complaint. It was a legal brief. 23 pages, single-spaced with footnotes. It cited the specific traffic stop, time-stamped to the second, with a detailed breakdown of every constitutional violation that occurred. It cited Terry versus Ohio on the absence of articulable reasonable suspicion. It cited Florida versus Bostic on the coercive nature of the encounter. It cited Mapp versus Ohio on the unconstitutional search. It cited Section 1983 of the United States Code on civil rights violations by law enforcement. It cited Riverside Police Department General Order 4.7 on the required justification for traffic stops, and General Order 9.2 on the legal requirements for vehicle searches. He attached his own phone recording. He included GPS data confirming his location and speed throughout the encounter. Every word was precise. Every citation was accurate. Every claim was airtight. Then he signed it. Not as chief of police, as a private citizen. Marcus D. Thompson, resident of Riverside, California, because he wanted the process to work the way it was supposed to work for everyone. Not faster because of who he was, just correctly. He submitted it to the Office of Internal Affairs at 11:47 in the evening. The Riverside Police Department's Internal Affairs Office received the complaint early Wednesday morning. Lieutenant Carol Emerson, a 20-year veteran of the department, was the senior officer assigned to review incoming complaints that week. She opened the filing, began reading, and stopped somewhere around page 4. Then she went back to page 1 and started again. Then she picked up her phone and walked down the hall to the deputy chief's office, because the name on the complaint, Marcus D. Thompson, was the same name on the plaque that was currently being installed on the chief of police's door. Kowalski had stopped and searched his own chief. By Thursday morning, 38 hours after the complaint was submitted, Brad Kowalski had been placed on administrative leave pending a full investigation. That timeline was extraordinary. Standard procedure for this type of complaint typically took 2 to 3 weeks just to complete the preliminary review. 38 hours meant the material was so clear and so serious that no delay could be justified. Lieutenant Emerson pulled Kowalski's body camera footage and watched it. Then she pulled every recorded traffic stop Kowalski had conducted in the preceding 12 months. Then she pulled his full personnel file, including the 3 prior use of force complaints and the 2 settlements. And then she looked at the numbers. Of Kowalski's last 206 documented traffic stops, 171 of them, 83%, involved Black or Hispanic drivers. Of those stops, 61% resulted in a vehicle search being conducted. Of those searches, fewer than 4% resulted in any finding of contraband or any citation being issued. Read that again. 83% of stops targeting people of color. 4% success rate on searches. Those are not the numbers of an officer responding to suspicious behavior. Those are the numbers of an officer using race as the primary factor in deciding who to stop. The investigation that followed lasted 11 days. 11 days that confirmed every single thing Marcus Thompson had written in that 23-page brief. The formal findings were released in an official departmental statement. The investigation determined that the traffic stop of Marcus D. Thompson had been initiated without specific articulable reasonable suspicion as required by law. The search of his vehicle had been conducted without consent, without probable cause, and without any applicable legal exception, rendering it an unconstitutional search in direct violation of the Fourth Amendment. Kowalski's conduct reflected a documented pattern of racially disproportionate enforcement, and the review of his body camera history uncovered something that made the entire case significantly more serious. On 4 prior occasions, during active traffic stops in the Glenbrook district, Kowalski had manually deactivated his body camera. The recordings showed the footage going dark, followed by a gap of several minutes, followed by the camera reactivating. He had never reported these gaps, never explained them. The stops themselves had never been reviewed. Those 4 incidents were immediately referred to a separate expanded investigation. The department's recommendation in the Thompson case was termination. Brad Kowalski did not wait to be formally dismissed. He submitted his resignation on September 24th. His 17-year career ended because of an 11-minute stop he chose to make against a man he assumed didn't belong in an expensive car. The city initially declined to release the body camera footage to the public, citing an ongoing personnel matter. 3 local journalists filed simultaneous public records requests under California's Public Records Act. Within 72 hours, the city's legal counsel authorized full release. When the footage hit the internet, it exploded. Major news networks picked it up within the hour. By midnight, it was trending nationally. Civil rights attorneys posted frame-by-frame breakdowns on social media. Law school professors and constitutional law classes used it as a live example of Fourth Amendment violations. Police accountability groups embedded the footage in policy briefings sent to over 60 city governments across the country. 42 million views in 3 days. The public reaction was not simple. It never is. Some people praised Marcus for his composure, his knowledge, and his decision to use the formal complaint process rather than escalate in the moment. Others argued he should have identified himself immediately and prevented the search from happening at all. Some pointed out, honestly and correctly, that this outcome only unfolded the way it did because of who Marcus was. Because he had the credentials, the knowledge, the recording, and the position to make the system respond. That criticism landed. Because it is true. And Marcus said so himself in his public statement. He said he did not want this story to be about him. He said it needed to be about the thousands of people who go through the exact same experience without a law degree, without 20 years in federal prosecution, without a platform, and without any outcome at all. He said that was the work. That was why he accepted the job. In the weeks that followed, the Riverside Police Department announced a series of mandatory reforms. All patrol officers were required to complete a comprehensive refresher course on Fourth Amendment search and seizure. Law, taught by a constitutional law professor contracted specifically for the purpose. An automated flagging system was implemented so that any officer who deactivated a body camera during an active stop would trigger an immediate supervisory review. The complete demographic data from Kowalski's 206 traffic stops was released publicly, and a new civilian oversight panel with subpoena authority was established to review traffic stop demographic data every quarter. After the footage went viral, 4 additional Riverside residents came forward with complaints about stops they said felt racially motivated. All 4 had been previously dismissed. All 4 were reopened. Marcus D. Thompson reported for his first full official week as Chief of Police of the Riverside Police Department on September 25th, 13 days after the traffic stop. He walked in, sat behind his desk, and got to work. Brad Kowalski, as of this story, no longer works in law enforcement. Here's what this story is really about. Because it is about much more than 2 people on a street corner. It is about the enormous distance between the rights Americans are promised on paper and the rights they are actually able to exercise in the real world. Most people do not know that a general reference to crime in an area is not enough legal justification to detain a specific individual. Most people do not know they can refuse consent to a vehicle search. Most people do not know that staying calm, asking the right questions, and recording the interaction are among the most powerful tools available to them in that moment. And some officers, in some departments, in some cities, have quietly relied on that ignorance for a very long time. When they encounter someone who knows every answer to every question, who can name the case law without hesitation, who understands exactly what they can and cannot legally do, the dynamic changes completely. The badge stops being a conversation. Ender. The uniform stops commanding automatic submission. Knowledge becomes the equalizer. The tragedy is that it shouldn't need to be. Rights should be the equalizer. The fact that they aren't is the real story. Some people asked after this went viral why Marcus didn't just tell Kowalski who he was. And that question deserves a real answer. Consider what that argument requires you to accept. It requires you to accept that a black man in a legal vehicle, doing nothing wrong, needed to prove that he was important enough to be treated lawfully. Every other driver who gets pulled over doesn't need to prove their status. They just need to not be breaking any laws. Marcus wasn't breaking any laws. The law was entirely on his side. He had no obligation to do anything more than what the law required. The fact that exercising legal rights felt dangerous, the fact that staying silent felt like a risk, tells you everything you need to know about the problem. So what do you take from this story? You take the knowledge that you have the right to ask why you were stopped, clearly and calmly, and that question is completely legal. You take the knowledge that you do not have to consent to a vehicle search, and that saying so clearly and on the record matters. You take the understanding that documenting the interaction, however you legally can, is one of the most important things you can do in that moment. You take the reminder that formal complaint processes are slow and imperfect, but they create records, and records have consequences, as 17 years of pattern behavior in Kowalski's file ultimately proved. And you take the commitment to push for a world where none of that knowledge should be necessary for basic, decent, constitutional treatment. 1 man, 1 traffic stop, 11 minutes. The end of a career built on unchallenged bias. Marcus Thompson's story shows that you can know your rights and use them. You can stay calm when the pressure is highest. You can document the violation and force the process to work. And sometimes, not always, but sometimes, you can win. Not every story ends this way. Not every illegal stop gets investigated. Not every career gets ended by its own misconduct. Not every complaint changes anything, but this one did. And every person who watched that footage and learned something they didn't know before, carries a piece of that forward. That is what matters. That is the legacy. Not just a man who became the first black chief of police in a 94-year-old department, but a man who showed 42 million people that the badge does not automatically win, that the assumption does not automatically hold, and that the man in the Lamborghini belonged there exactly as much as anyone else on the road. More, actually, because that road was his city, and that city was now his to lead.